Article 5, Paragraph 6 of the India-USA Treaty, holding subsidiary relationship. Now what can happen is, let me just put this across. Suppose this is a foreign company which is a tax resident of US. It has a subsidiary in India where it is exercising control, right? It also, when I say it also, even the Indian company has a subsidiary in UK where it is exercising control, right? What this paragraph provides is that just because the foreign company has an Indian company or the Indian company controls a company which is there, not be treated that a PE exists. The fact that a company which is a resident of a contracting state controls, okay, or is controlled by a company which is a resident of the other contracting state. So the fact that ICO, which is a resident of India, controls what? The UK sub, or is controlled by the US sub, US parent, right? A company which is a resident of the other contracting state or which carries on business in that other state, whether through PE or otherwise, shall not of itself, just because of this fact. There is no denial of the fact that even in these cases, they may amount to a PE, right? But just because of the fact that I have an Indian company which is a subsidiary, that fact by itself, not of itself, constitute either company a PE of the other. This UK sub cannot be a PE of Indian company just because the Indian company controls it. Similarly, this Indian company cannot be a PE of the parent, US parent, just because of the fact that the US parent controls the Indian company.